pending criminal petition for tomorrow.
Next week. Already list is out. Next week.
Can it be for orders for tomorrow? Long
Orders.
pending, 4 orders.
Or orders Thursday. Or
Thursday.
Friday.
Friday, my lord, I'll have another matter in a different court.
Thursday.
Thursday,
Huh?
not possible
For orders.
my lord.
List is already out
My
for
lord.
tomorrow.
Understood. Obliged.
Lordship, I like to mention item number 27, supplement.
27.
This matter may be listed after 3 weeks. Lord. Moreover, I have often consent from the opposite party.
This is where the contract was awarded before the NIT.
Yes.
So dispose of it. What's there? You are for?
For the private respondent.
Is it correct?
Lordship, I have to take
Who is for the state? If the work is awarded before the tender, how can it be permitted? Who is appearing for the state? Your beneficiary were not concerned. Are you ready?
No, Your Honor. It's for the instruction.
Very simple matter. Work has been awarded before the NIT was issued.
Yes, Lord.
Finish. As you wish. On the prayer of Mr. What?
M. Tanga, Lordship.
N.
M. Tanga.
M. Tanga, learned counsel for the petitioner. List this matter after 6 weeks. 6 weeks.
3 weeks, 3 weeks, Lordship. 3 weeks.
Is there any interim order
No, Your Honor.
after 3 weeks? Mr. T. Gyatso, learned counsel for respondent number 3 is present. None appears for the state. List accordingly. List is read for.
Hello, Lord.
May I please, Your Lordship? I beg to mention items 10 to 14.
10 to 14.
Yes, the respondents have filed an additional affidavit
Yes.
this morning. So I need some time for instructions. Can the matter be taken up day after tomorrow? Since this is an urgent matter, we would have liked to dispose except say for this.
On the prayer of MS N. Danget, learned counsel for the petitioner. With the consent of learned counsel for the respondents. List this matter after on
Day after tomorrow, Thursday?
13.
Day after tomorrow is? Yes,
1306/2020.
there is an interim order, Lordship.
Interim order was earlier circulated. Up to 14.
Yes.
What is the matter?
Matter is regarding land acquisition,
Compensation.
compensation. Yes.
Your challenge is
My challenge is my properties have not been taken into account. Referring to an order, referring to violation of order which was issued before the notification.
very complicated.
Not really, Lordship.
Don't make it complicated. Otherwise,
No, it's only that they are saying
we'll not be able to dispose of.
they are saying that we have violated some order which was prior to the notification.
Who else are appearing?
He's appearing,
My lord, I am appearing
Sit.
for respondent number 4.
Huh?
Deputy Commissioner and Land Department.
Okay. Are you ready? We'll dispose it of day after tomorrow.
Yes, madam.
Ready? We'll see.
Oblige.
What is that? Right. In this manner. Yes, what is this?
One of this application has been filed for quashing of FIR loan
Yes,
on the basis of settlement between the parties. Settlement agreement is at page number 19, Your Honor.
charge sheet also been filed.
Charge sheet has been filed, Your Honor.
Okay,
And the accused was served a summon by the Honorable Court to appear before the JMFC UPR on 12th of this month.
do you appear? What's there?
Your Honor, because the parties have already settled the matter,
Doesn't
it's no
matter.
use pursuing
It,
the
it
case any
doesn't
further.
gives you, I mean, the right, it doesn't mean that it will get automatically be quashed just because you have compromised. We'll have to see.
Yes, Your Honor, but also the
It depends
sections.
on the facts of the matter.
Yes, Your Honor, and the sections that has been invoked, that the accused has been charged under, it's section 279 and section 338. 338 is compoundable. However,
Yes.
section 279 is non-compoundable.
What is 279?
It's for rash driving, Your Honor. No
Yeah.
offense.
This is very dangerous.
The imprisonment is only up to 6 months, Your Honor. And moreover, the victims have been duly compensated by the accused person.
Any casualties?
There were 2 casualties and the medical expenses were taken care of the accused. And he has also compensated an amount of rupees 10 lakhs. And the same has been executed also in the way of settlement agreement between the parties.
Yes. Yes, what do you say?
My lord, so far the agreement is concerned, it appears that, my lord, an amount of rupees 10 lakh has been paid as a compensation, my lord. And so far 279 is concerned, my lord, the punishment is only 6 months. And in respect of 338 is a compoundable offense. Therefore, my lord,
279 is, what is punishment?
279 is 6 months punishment.
6 months.
Yes, my lord. 338 is compoundable.
In that case.
Yes.
Heard MS T.Y. Bhutia, learned counsel for the petitioners. This is an application under section 482 of CRPC, 1973, praying for enforcement of criminal proceedings of what case? What is the
This is-
case number?
This is Naharlagan PS case number 212.
Not PS case.
2016.
Year case number 826.
GR case is 826, Your Honor.
826. 826 of 2016.
Huh?
826 of 2016.
From where you get it?
Page number 24.
24.
826.
24.
24, Your Honor.
Someone. Eight to six of 2016, under section 279, oblique 338 of IPC, pending before the
JMFC. Apumpai,
judicial magistrate, UPR,
UPR.
on the basis of the settlement between the parties. Call for the scanned copy of the trial court reports. Mr. J. Sirik, learned public prosecutor. Appears for state. Next better. That's all.
Yes, Your Honor, there's an interim prayer. Until the disposal of this matter, the proceedings before the trial
Okay.
court may be suspended.
Pending next matter. Considering that the parties have, the petitioners have entered into a settlement. Pending production of the skin record. The records, further proceedings of GR case number so and so, shall remain suspended, shall remain stayed.
Deeply obliged.
Please, after 4 weeks.
Deeply obliged.
Item 2.
I was only, no?
Ah.
I was only.
Ah.
Only to the extent how the post earlier shown to be as in reserve APST has been converted to a non-reserve post. That to that extent, the Standing Council and management has to bring the records.
So otherwise, there is no dispute so far as the applicability of 2006 rules
Yes,
and eligibility also there is no dispute. What
Yes.
are eligible
eligible,
in
yes,
terms of education qualification or whatever,
yes,
or the length of service.
yes,
There's no dispute.
no dispute.
Yes.
Just check the relevant document. First one is here was breakup of the vacancies, regular vacancies. From 2012 to 2015, there were 4 vacancies. And all the vacancies were not reserved for APSP. Carry forward. It was carry forward. And the other document, my lord. In the post-based roster. My lord, we see in serial number 5, my lord. That was kept unreserved, but since there was no eligible candidate in the department, my lord, the APSC candidate was given the promotion.
Hmm?
APSC candidate was given the promotion in place of unreserved post. So that post was carried forward. And accordingly, this private respondent were given that work.
Second one.
Second, yes, in it's serial number 5, madam. That post was made for this unreserved category. But since there is no availability of this unreserved candidate, general candidate in the department. So one of the APSC candidate who was serving as the SK was given the promotion. So that post which was kept unreserved, as serial number 5, has been carried forward.
Is it permissible?
My lord, yes, my lord.
How?
My lord, there is a roster system, my lord. If there is this post, if it is not filled up by this general candidate, it will carry forward. Ma'am. That is the system the department is maintaining.
How many posts are there for promotion? Hmm?
That my lord, the previous instance, I don't have the item, ma'am. This post vacancy is up to 2015. From 2012 to 2015. Therefore, vacancy.
That is your stand in the affidavit. Is
Yes,
it
my
your
lord.
stand in the
Yes,
affidavit?
there's a clue on my.
Let us see. Just wait. 1, 2, 3.
Yes,
1, 2, 3.
yes, ma'am. Page number 8.
Yes.
That is statement made in paragraph 11 of the resolution being admitted by the Supreme Court. Where instead the government of Arunachal Pradesh by so that is so will introduce post-based roster in place of 100 roster. The same notification included state that starting with the earliest when roster point number 2 is filled by candidate belonging to general category. Candidate is shall be remarked utilized by general category candidate against point number 5. And point number 5 shall be remarked transferred to reserve force. And so on. And so for field more elements are adjusted in the respective roster. In the present case, the roster 5 number 5 is unreserved point, which has been filled by candidate belonging from APSP line point roster 6, 7, 8 were also filled by the candidate belonging to APSP. Thereby, the unreserved point in number 5 has been carried forwarded to next roster point to 9. Therefore, the same vacancy is unreserved post as the Gens entry was collected all respect. Hence, the recommendation of VPC is in conformity with the existing rules and regulations.
Then why you have earlier said it's a reserve post?
That is my lord. By mistake, my lord. Otherwise, my lord, documents show that it is unreserved matter.
What documents?
Yes, I have placed the record, my lord.
Where you have said about the earlier decision?
But in the advertisement, we mentioned as this
Not independently.
reserve. There is no statement, this is my evidence matter.
Your affidavit is based on the earlier round of proceedings.
Otherwise, also can see that my lord, the ACR of the petitioner is not good. It is also reflected in that. That was of course not the ground for this, not for considering the case of the petitioner.
If that is, if it is not the ground for consideration, don't make submission.
Yes,
We are not interested.
yes.
Yes. Okay.
But if I have correctly heard, that particular post was unreserved and it was utilized for the reserve category. My lord, kindly have my affidavit. two small documents, my lord, then I will rely on para 10 of R.K. Sabharwal judgment.
Respondent number 4.
Yes.
Which,
Page-
which documents?
Yeah, NT James, page 24. It appears, my lord, 50-50 roster. Page 24 of my affidavit, there is one annexure post series. My lord will see at serial number 5.
Yes, that is what he has shown.
Yes. So in that case, my lord, then these concurrently sits, kindly turn back to page 21, that 100-point roster which I have next. Well, only two paragraphs, para A and B. The ratio for promotion and direct recruitment quota should be worked out on the basis of total number of posts in a cadre. Stroke grade. Accordingly, a roster in the ratio of 50-50, here in our case, it is 30-50, 80-20, 75-25, or as prescribed in the rules for the post in the rules for promotee and direct recruit should be drawn in relation to the number of the post in respective cadre grade. At any point of time, the number of employee recruited on the basis of promotion or direct recruitment should not exceed the ratio prescribed in the respective recruitment rules. Here I'm pausing for a moment, like, Malone has seen at page 24, serial number 5. Now the ratio was to be maintained, but due to non-availability of a ripened candidate under the unreserved quota, it was utilized by the APST. In case it is found that either of the promotee or direct recruitee exceeds the ratio prescribed, the vacancy which has occurred in the cadre should be filled up by promotion or by direct recruitment till the ratio prescribed is achieved. Thereafter, the vacancy should be filled up by promotion if it is vacant against promotion quota, and the vacancy should be filled up by direct recruit. If it is vacant from direct recruit quota, the ratio as prescribed in the relevant recruitment rule, service rule must be maintained strictly. B, the percentage of reservation in the ratio of 80-20 of the post reserved for APST and 20% of unreserved posts for general category candidates, or such ratio as prescribed in the recruitment for the particular post should be worked out in relation to the number of posts in direct recruitment quota. The vacancy arising in a cadre against direct recruitment quota after the initial posts are filled as per the reservation order should be filled up amongst the category to which the post belong in the roster. For example, APST person, this is important, the APST person holding the post of roster 0.1611 retired, then these slot are to be filled from amongst the person belonging to the APST. Similarly, if the person holding the post at 5, 9, and 15 retire, then these slots are to be filled from among the general category candidates or by APST candidates on their own merit. In case it is found that either of the reserve or unreserved category exceeds the ratio prescribed, the vacancy which was occurred in the cadre should be filled up. Well, therefore, my lord, the document itself speaks, my lord. Now, what had happened is, since the unreserved post under the roster point, where the unreserved category candidate was not ripened for the promotion, then it was utilized. So therefore, the very objective of the roster itself is that the ratio point has to be maintained and one cannot exceed. So therefore, it was at that particular point, the government has taken a particular decision, my lord. So therefore, that, my lord, yesterday I was referring to that section 14, one of the general clause of Act. Power conferred to be exercised from time to time, and this exactly has been exercised like that. Now, therefore, my lord, the mandate that is required under para 10 of the R.K. Sabharwal judgment. No, so it is a question of carry forward. So therefore, there was no infirmity in my case when the state government in exercise of their power under section 14 of the General Clause Act has given me the promotions. Now, since my lord, para 10, that my lord is aware, but still just I'm placing. So since my lord is aware, my lord, on the principle that if SC, ST are not available, then state can carry forward the post. So therefore, under this power, they have carried forward, they ought to carry forward the post law. So therefore, there was no infirmity in my case when they have. My lord, at this point of time, my lord, since I have retired, my client have retired, and the petitioner also shall not have any grievances, it would be apt from our end, my lord, to make a submission to an extent that let my promotion be upheld, and against which the vacancy, if any, is lying vacant or has arisen, be considered in favor of the petitioners. Well, that will suffice the equity for all of us.
Para 7.
7 and 10.
Not para 10, para 7.
That is, madam, in para 7, that Indra Sani was reiterated.
Applicability of the present case.
Yes, yes.
According to you.
And madam,
My pleasure, Lordship.
That's all. That's all.
That's all, madam.
You
So,
want that your promotion should be protected
yes.
personally.
No,
So
sir, no,
you
sir.
have not worked. What is the promotional post in this case?
DLRSO.
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 District Land Revenue and Settlement.
A promotion was on which year?
2018 itself.
18.
But I worked
You
for a few days. I
retired,
worked for a few days and then I was rewarded.
retired on, retired on,
Retired, Miller, exactly. I don't know.
and just, okay.
Lordship. If the government had filed affidavit in the manner in which they are bringing today, then maybe I would have something to say. But
No,
yeah.
what they are saying is,
yes,
there are, it's 80-20.
yes,
But in
I'm
essence,
getting what they're saying.
ah.
It's a carry forward
Carry
because
80-20,
because that
so all
person,
along, the APST were appointed,
yes,
including the slot number 5.
yes,
So since the non-AP, this has been, percent has been already completed,
yes,
80-20, 80% has been already completed,
yes,
represented
yes,
by the APST. Next post is for the
yes,
non-APST.
yes,
On eligibility,
Yeah.
it has been that slot number 5,
yes,
which was, what do you call, occupied. Utilized for the APST.
yes.
So the moment it has been 80% has been.
Since the office memorandum also says that, I have nothing to say on that matter. But what I'm saying is, if they had made the affidavit in this way, in these details that they
Yeah.
have mentioned now, then I would have maybe made some more research on that. But since the
Would you like to have more research?
yes, but since the respondent has also retired, and the post should be vacant, it may be in the order that if any vacancy arises, I may be considered.
So we need not determine
Yes,
whether you
Lordship.
are entitled or not.
In view
in
of that,
that phase.
I cannot say anything.
Is it?
Yes,
There was a perpetual illegality.
office memorandum also says that the next has to be adjusted. So
Out of 9,
yes,
8 already given. It's more than
100%.
100%.
now if page number 52 of my writ petition, if there is an excess and if there is some post which has to be filled up, that excess that any retirement promotion and all those vacancies will be adjusted.
Now, suppose
Yes.
there is a difficulty again.
Yes,
If somebody is there
yes.
who is eligible as a non-APST, I think if we
Actually, there is no
if
one.
it is to be maintained,
Yes,
only carry for only it can be utilized if someone is available.
yes,
I mean, as a general category.
yes.
I think out of 9, how much? 80%?
7.
One more has to be filled up. You are in number
fact,
1.
I have-
Are you in number 1 now?
Yes, I'm in number 1.
Still 2 has to be appointed.
But there is no AP, no APS.
I don't
not-
know if if they utilize it again, we don't know.
Yes.
They may utilize it, but we cannot command them to utilize it.
No, I have seen the seniority list.
Yeah.
There are no APS, non-APS.
There will be a great hostile discrimination will not. And the concept of, intelligible difference will also not come into, in any case, Milord.
No, there's no question of concept coming in. It's clear as noonday.
Yes.
Except
So what do you
for
want?
Lordship.
What do you want?
Lordship may pass any order.
Because my client is suffering.
But Lordship,
reasons.
it may be stated that if there are vacancies, I may be adjusted.
Subject to the fulfillment under law. That is always open to me, Lord.
My lord, this writ petition has been filed, basically challenging the appointment of the private respondent, my lord.
That
So therefore, my lord, if even if there is vacancy, my lord, in this such order may not be possible.
Okay, welcome.
No, if there's a vacancy, if you want to fill up, why not consider her?
Yes, my lord, if there is vacancy, obviously,
Since you have utilized general category post at the earlier point of time, you do the same thing. If there is no candidate,
Yeah, well, that is always possible because subject to the
availability
availability of the
yes.
unreserved.
mandamus not as such will provide you
Yes,
that your case may be cancelled, but the writ petition is dismissed.
yes. By my case may be considered, but then,
But your case, writ petition is dismissed. All right,
yes,
Right.
but I'll provide something,
yes,
not by a mandamus.
yes.
I'll observe something.
Oblige.
Heard Miss MS N. Dangan, learned counsel for the petitioner. And also heard Mr. D. Kamdu, learned distinct counsel for the respondent number 1, 2, 3,
Yes, ma'am.
and Mr. T. Tara for respondent number 4. So they were stay.
Yes,
Their promotion was stayed.
yes. I'm still holding the post of Delaware, so as per the earlier, as per that,
You are holding.
yes, I'm holding in officiating basis.
My lord may not say anything.
I'll say something. This court will say something. You have been allowed her to, him to continue. And he is eligible.
What is
And
essay?
there's no other eligible candidates, the general candidates. So
You should not say that because the department also will suffer if there is nobody holding the
If
post.
there is availability of
He
the
should
post, my
be-
lord, surely he
will direct you to consider.
If the EPC is not conducted, if there is no candidate, will they leave the post vacant?
Okay.
my lord,
He should
We'll pass down.
oblige,
Writ petition dismiss. With certain observation I'll make,
oblige.
including for you also.
My pay
In
protection.
fact, I'm thinking he should be worried about the department of a post being vacant without any person. I think he's thinking about himself, not the department. Oblige.
My lord may just observe that the department, the authority may consider the case of the petitioner if the
Obviously,
post is available. May not say that department shall consider that. Instead of using
Why
shall,
conjunctive, disjunctive and all those things.
Oblige.
send it to Chairman.
My lord, all those works, at one point of time, the assistant engineer and the executive engineer says that work has been completed physically. Now he takes a contradiction statement after 1 year, saying that some of them are this person, some of these are this person. Now again, they comes up with certain thing, which is, something intricacies of authenticity of their actions, my lord.
Yes.
Then my writ petition has to be allowed. He was asked to bring certain instructions. That person.
Regarding, although they have not actually furnished the latest instruction on this issue, although they have sent. And regarding the lordship, I'm sorry, they have not, the outcome of the disciplinary committee, they have not provided.
No, we'll go later to that. We'll see later. First, you come to the merit of this.
Well, shall I proceed or the state council will be allowed to advance the argument?
No, your case is that
NIT was there,
you were given after the NIT, you were given the
work
work
executed,
you have executed.
Yes.
In the meantime, somebody approached the court.
yes.
Court has directed to dispose of or representation or something like.
And
Consider,
that-
reconsider.
Yes.
without
No,
you
no,
being
to-
implemented
To consider the grievances of the
Yes.
petitioners.
Yes.
But the appeal order was passed behind our back.
Yes, now
Therefore,
the,
that is
the
a great-
authority on the pursuant to the order of this court to
Well-
consider his case without hearing you,
Correct.
decided to go for retender, which you are challenging on the ground
On the ground.
that firstly, you have not been heard.
Yes, that
All right.
necessary principle
And
was
on merit, by the time you have completed the,
complete. And they have given the report.
they have given it. That's
They, that is my case.
what more I should hear you.
No, no, I,
Anything more.
no, my lord, no,
all.
absolutely not. Except that's why, my lord, I made a respectful statement that should I proceed rephrasing the facts or the state council be allowed to advance the argument.
I think on that day,
Yes,
we've heard you. I
But
just wanted
my lord
to
will
know.
kindly conclude that the action of the state is not in consonance what is to be done.
Sir, for that I'll have to hear him first.
Correct, my lord.
I have
So
heard you, I'll
therefore-
hear him, I'll hear him and I'll hear them.
Correct, my lord. I'll-
Yes,
Lordship, this is the instruction. Lordship. And I have, on the basis of the additional affidavit by respondent number 2, Lordship, I have prepared this list.
just wait, just wait.
The affidavit. No. Completed it.
So latest is after the cancellation, except for your, the same stand you are taking as in the affidavit, saying that you have issued a completion certificate under duress, which you are, which the assistant engineer has sought to, I mean, justify.
Yes, Lordship, as per the
Number one. Number two, so far as the status of the work is concerned, whatever you have given in the second by the assistant engineer, it remains the same. Because after the order of secretary to cancel the work, nothing has progressed.
Lordship,
And then
although the progress report was issued by the assistant engineer, Lordship, in our affidavit, we have, in respect of this, Lordship, 578, in respect of this, we have said that the photograph coordinates by engineer has not been submitted, therefore, the work is presumed to be not commenced, Lordship. So, as per the latest instruction, only Tarak portion has been completed. Other than that, the work is not completed, which we have taken in the additional affidavit, Lordship, it remains same.
No. Basic grade of your additional affidavit.
Yes, there are two.
So you are basically stand by what you have, I mean, taken in the affidavit. Nothing new. It remains the same. Yes.
Here, my lord, my son is very simple, my lord. All the IP record, my lord, placed before this another record by the state respondent is prior to this to my documents, my lord, that is official documents, which I place on record on to affidavit opposition, my lord. Now, in such a situation, my lord, when the stand of the state is not conclusive, my lord, my understanding of this case has two parts, my lord. One, violation of national justice, my lord. And any pass, my lord, is interpret this on record, my lord. Surely consequence, my lord. After if this order interfere, my lord, they simply start for payment of the claim, my lord. Now that will affect that will dealing with the my lord will dealing with the public money, my lord.
This is the reason I want him to make the stand very clear.
That's why, my lord. Therefore, my lord, when the state responding,
Even if he is not completed, whatever completion, it's on record
my lord,
and no payment has been made as on that.
no, my-
Right? Have you received any payment? No. So there will be multiplication of litigations.
therefore, my lord, my humble, my understanding, my lord. This for violation of national justice, my lord. This impugn order, my lord, can we surely interfere with, my lord. With a direction, my lord, the given the chance to all the party, my lord, to place necessary peg, my lord, before the competent authority, my lord, to decide whether the work is complete or not complete, my lord, by the status, my lord. Otherwise, my lord, simply interfering or simply in violation of national justice, when the extent of the state is not conclusive, my lord, that will surely affect the public at second, my lord, any pass, my lord. So my humble understanding, my lord, this impugn order may interfere with, my lord, with that additional direction.
Appeal order has to be.
Yes, my lord, that is
has to
a
go.
violation of national justice, my lord. That
Has
can be
to go.
interfered, my lord.
Okay.
But simply on that will not do, my lord. Yes, my lord, I have placed on record, my lord, the latest official documents, my lord, saying that, my lord, work was not complete, my lord. Now, if that is so, my lord, that is not disputed by the petitioner, my lord. They did not file any affidavit, my lord, in regard to my this official document, my lord.
No, see, that is the basis. If you say that the impugn order has not been passed
My lord.
in accordance with law,
No, my lord.
it goes, better ends there, he should be allowed to continue. If he has not completed,
And not complete, my lord.
by making will not go delve into the whether it has been completed or not.
Yes, my lord.
First, we'll see if the impugn order is not in accordance with law, we'll set aside and we'll ask him to complete.
No, my I to that
That's
extent,
all.
I consider, my lord, this order is not in accordance with the law, my lord. In
He
especially,
has to complete.
yes,
If
my
not completed, if he
Especially-
has completed, make the payment, that's all.
Well,
Of course, he is not
my
asking
lord.
for the payment, we'll not do that.
Mhm.
We'll ask him to, we'll set aside and we allow him to continue complete the project, if not completed, in accordance to terms of the tender and work order.
My lord.
That's all. You complete the work.
Yes.
If you have not completed, you are saying that, see, they are saying that it was under the duress. We'll not go into that, whether under the duress or not. We'll assume that your allotment or award was correct. You have not been hurt and this order has been passed.
No, my lord. No, my lord. My submission, my lord. His allotment, my lord, is not correct, my lord. I say, my lord, the impugn order, my lord, the impugn order secretary, by who is, my lord, their allotment order was cancelled. That is incorrect, my lord. Yes, that is violation of national justice, my lord. But prima facie, my lord, the competent authority
That is
to decide, my lord, whether the contract, my lord, was allowed in terms of the law, my lord, that need to redressal against, my lord, giving chance to all the party, my lord, including us, my lord. They need to be heard by the secretary, my lord.
It's in 2000, it's of 2001? No, work order was
2018.
18.
But then within the.
What was the issue? Why you are saying that his allotment was not
My
correct?
lord, we were the L1, my lord. We, instead of my lord arbitrarily, they were awarded of my lord. According to within 10 days, my lord, we filed a representation with the competent authority, my lord, secretary, my lord. Now that was not considered, my lord. Accordingly, we approached this honorable court, my lord,
Yes, you go.
challenging the tender of my tender awarding them, my lord. That is the issue, my lord. Now, in terms of that, my lord, direction issue, my lord, to the secretary to consider our grievances, my lord. While hearing that, my lord, their tender cancel. As that was not the secretary say, my lord, the award, my lord, was not award in terms of the rule and regulation, my lord. So that is a remind, my lord. My humble understanding, my lord, the only cancellation order, my lord, liable to be interfered, my lord. The other grievance, my lord, need to be heard by the competent authority, that is secretary, by giving fair chance to all the party, my lord, including us, my lord. If, my lord, during the hearing, my lord, if suppose they can produce, my lord, the overall complete, my lord, then there is, we may have no grievances.
What if the work is completed?
Complete. During the hearing by the secretary, competent authority, my lord.
No, he said he has already completed.
No, my lord, that's why, my lord, I have produced a official record before this honorable court, saying that was not completed, my lord, that was issue on duress, my lord.
Suppose if after hearing, if it's found that you are entitled to be awarded,
Award, my
then
lord.
what about his work which he has claimed to have completed?
Then, my lord,
He has a remedy of
my lord,
civil suit, my lord.
then
You claim your
I
damages
say-
from the.
vice versa, he
You
has a
have not
remedy, my
put
lord.
into challenge the entire tender proceedings and.
He has a remedy to approach a civil court, my lord.
No, no.
If suppose they have complete work, my lord, and authority say, my lord, that was not awarded in terms of the law, my lord, if we are not going to pay you, my lord, then he has a option of civil court, my lord.
You go to civil court. Get some money from there. My lord, we'll see that page 6.
Now here, my lord will, my humble submission, my lord is circumspect, my lord. Now, authority, my lord, one authority saying, my lord, this was complete, there's certificate, my lord. Now, but on the record, my lord, the affidavit, my lord, the state is not conclusive, my lord. Only one authority issued him a completion certificate, my lord. Now, contrary to that, my lord, I have produced a record, my lord, between the communication between the two officers, my lord, saying, my lord, no, that was not complete, my lord. So in such situation, my lord, my humble submission, this is my lord, while exercising a writ jurisdiction, my lord, will not go into those aspects of the case, my lord. Simply, my lord, as impugn order is bad by violation due to violation of national justice, my lord will interfere that, my lord, and granting liberty to respondent competent authority, my lord, to look into our grievances, my lord.
Yes.
My lord, only one paragraph I may request lordship to
Which
kindly
one?
overthrow,
Which
go
paragraph?
through that additional affidavit by the respondent number 2, page 6, my lord. Page 6, one paragraph 2,
What affidavit?
additional affidavit by R2.
Affidavit in opposition. Yes.
My lord, kindly come to second para. Due to incessant rains and landslides in the
Where-
month of
where?
August,
Where it is?
page 6 of
Affidavit.
yes. Additional affidavit by R2.
Yes.
Hmm.
Page.
No, the page 6. Two small paragraph. However, no reply
Yes.
or report has been received regarding the above mentioned 5 work sites till date. 540 meters of water track at so and so, only 210 meter has been completed as per the report dated so and so, July 2018. Also, a complaint has been received from Ojang Fazing of Yaxing Blaze so and so, so and so, so and so Blaze, alleging duplicity of water track at Yaxing Blaze and other water track sites and procurement of double engine boats at Sishan. Now, this paragraph is important. Due to incessant rains and landslides in the month of August and September 2000, the sites were not accessible and hence no further reports were obtained as the works were stopped due to pending court case. Now, this particular two lines speaks in consonance with the work completion report given by the assistant engineer. That much, this clarification I wanted to make. My lord, may I request a moment, my lord? I'm required in court number 1, my lord. My submissions are over. My lord grants me the leave, I can. May I, my lord? Grateful.
How many petitioners are there in this case? How many writ petitions?
Five.
Five only. And see, out of same tender. Same tender. Out of same NIT.
It has been different, but in the same day.
Are you making sure? Is it the same tender NIT or different NIT?
Maybe looking for, different, different. Common same, common different.
How do you, what disposing the matter? Make it clear.
Here we have given clearly.
Hmm?
Here we have given clearly.
Where?
NIT, my lord, will find it at page number 18 in section number 2 in read petition 570.
18.
In read petition 578, my 578 to 1018.
Yes.
The same NIT.
Same NIT.
Same day.
Same day, my lord.
So there are eight component, I mean,
Packages.
packages.
Hmm.
So how many of you are here?
No, there is. Second, was you ek, no?
You are heard Mr. T.T. Thara, then counsel for the petitioners, common judgment, huh? And also heard Mr. Yes, you want to say something?
No, my lord, the respondent has expired and I have no instructions, further instructions
In
in WPC 578.
578.
578.
My lord, that NIT number 083.
Respondent 7,
Serial number 3.
Serial number.
the proprietor.
In item,
Uh,
the writ petition.
In all the writ petitions, Lordship,
Okay.
respondent 7.
Number 7
Yes.
expired when?
Lordship, it's been almost 2 years now.
578.
Oh, nothing.
Nothing.
Next is. I read up learned additional senior government advocate. For respondent number 1, 2, 3 and
1, 2, 3, 4, 5, 6. 6.
1 to 6. 1 to 6 and Mr.
8 months, 5.8
MS. And then council for respondent number 7. Within bracket, huh? Within bracket. Who has expired? The proprietor who has expired during the pendency of this writ petition. Huh? Bracket clause, huh? and Mr. El Perme. Land Council for respondent number 8. What about 9?
Line is not represented.
Next para is the issues involved in this batch of writ petitions. Similar. Same, the writ petitions are taken up together and for disposal by this common judgment and law. Next para. The common challenge within this proceedings is to the Indian order dated 10/11/2018 passed by the Secretary Water Resource Development, Government of Arunachal Pradesh. Where it is, impure order?
Impugned order is at page 36 now. That is
36.
10/10/2018. In all writ petition, because same pages are also same.
Whereby NIT dated 04/04/2018 has been directed to be cancelled. No, the work orders issued pursuant to the NIT dated 04/04/2018 are to be cancelled and to initiate the process of retendering. Experience. The case of the petitioners. In brief. Is that pursuant to the NIT being number page 18, being number dated 04/04/2018 for construction of water track water tracks at different locations. It's in where Pangin or
Yes.
different places
Eh,
within Siang district,
Siang district.
within Siang district. Different places in the district of Siang. Issued by the executive engineer, water resource division, Pangin. Within bracket, 8 packages. The petitioners were allotted the work order. When you were allotted work order?
I was allotted on
Agreements.
28/5/2018.
Commencement.
Commencement.
'28. All of you,
All.
all the petitioners
All.
on 28/05/2018. It is the contention of the writ petitions that after awarded the work, they have executed the same, started execution and then completed the works which have been allotted to them. Next, in the meantime, you are the only one who has filed a writ petition.
No, my lord,
Three complaints.
three, my lord.
Three writ petitioners. Okay, in one writ petition.
My
In the meantime, next para, some of the unsuccessful bidders filed a writ petition before the High Court. Writ petition being WPC 280 of 280 oblique, comma, AP 2000, bracket clause 2018, within bracket, MS, Messrs, Engineer Oin Tamuk and others by state of AP, bracket clause. Assumes the award of contract to the petition. This court, the writ petition was disposed of on 13/06/2018 at the motion stage with a direction to the responding authorities to dispose of the representation of the petition. Where is the judgment order of this court?
Order of page 30,
Okay, 35.
30 to 35.
Next bit, pursuant to the order of dated 13/06/2018, first in the above petition. The impugn order, the respondent authority, namely Secretary within bracket WRD, Government of Arunachal Pradesh, by the impugn order dated 10/10/2018. On consideration of the materials have concluded that consideration of ineligible bidders in technical bids for financial public price bid by ignoring the stipulated terms and condition of the bidding document is in violation of stipulated rules and allegation illegal ab initio. And L1 bidders have been ignored due to wrong interpretation of appropriate clauses of the CPWD works manual and rejection of L1 bidders is a gross violation of CBC guidelines, security works manual, and guidelines issued by Planning and Finance Department. Mr. Accordingly, the concerned authority was directed to cancel the work orders issued to the petitioners and to initiate the process of retendering. Hence this present petition. When these present petitions, next bill. Mr. T.T. Thara, then also to the petitioners, submits them. The impugnator has been passed without hearing the petitioners. As the petitioners were the successful bidders and found to be responsible were awarded the works for construction of water tracks in different areas in the district of Siang. Mr. In the writ petition, though the petitioner was added as 30 respondents, no notice was given to the petitioners, and the same was disposed of on 13 06/2018 at the motion stage. He further submits that since the period of completion is of 3 months.
Yes.
The complete period of completion is stipulated in terms of the contract was of 3 months only come up. By the time the impugn order was passed, by the time the impugn orders issued, the petitioners had completed the works allotted to them in terms of the opposite NIT. Mr. He refers to the completion certificate. Where is that?
NIT.
No. Completion certificate.
Completion. Where page 28?
Refers to the
29.
status report annexed with the writ petition to substantiate his submission that by the time the impugn order was issued, the engineer concerned has clearly given the status reports that the works have been physically completed. Therefore, he submits that the impugn order being not sustainable, be set aside. Mr. Next paragraph. Mr. Learned additional senior government while relying on the affidavit in opposition filed on behalf of the state respondents, submits that the impute order has to be rendered pursuant to the order of this court in writ petition 280 of 2018, whereby a clear direction was given to the respondent authorities to verify the original records with regard to the NITs and to pass appropriate orders. Mr. Having carefully, having careful on having been examined carefully, it was found that the L1 bids were ignored due to wrong interpretation of appropriate clauses of the CPWD manual works manual and such rejection of L1 bidders is a gross violation of CPC guidelines as well as the guidelines issued by the Planning and Finance Department. Therefore, the authority has directed to cancel the work orders issued to the petitioners and to proceed to initiate process of written. Having regard to the I did up next word. Learned State Council submits that though initially the assistant engineer of the concerned project has issued a completion certificate, issued a status report indicating the physical completion of the project by the petitioners. However, he has filed an affidavit indicating that such an status report was issued under duress. However, he placing on the documents as sought by this court has given the percentage of works where it is completed, and also the works which have been completed has also been indicated. He further submits that in view of the pendency of this writ petition and in pursuant to the impugn order, no further progress has been made in the entire project. Mr. MS N. Dangan and Mr. L. Perme learned consent for the private respondents, while disputing the plea of completion of works by the petitioners, on the basis of the stand taken by the state respondents, fairly submits that the authority ought to have heard the petitioners before passing the impugn order. List of. While not admitting that the petitioners were legally allotted the work and rather not legally award the work as the petitioners were not the L1, but the respondents were the L1 in the tender process pursuant to the NIT dated 04/04/2018. That means that matter may be remanded back to the respondent authorities for consideration by the for consideration after affording an opportunity to the petitioners as well as the respondents. Next question. The consideration has been extended to the submission of the council for the parties and also here is the materials available on the board. On perusal of the order of this court, was in WPC 280 of 2018. Dated 13/6/2018, the writ petition was disposed of at the motion stage with a direction to the respondent authorities. Now, with the direction to petitioners to submit a press representation stating their grievances, and on verification of the records in original with regard to the NIT dated 04/04/2018. To consider and dispose of by reason order by giving an opportunity, if necessary, to the petitioners. It doesn't indicate any opportunity to be provided to the petitioners, although the petitioners, all the petitioners were added as party respondent.
Yes, 7, 8, and 9.
7, 8, and 9. Only 3 in that case.
Yes, there are 3 of them.
No,
In my read petitions, they are added as 7, 8.
7. No, in his read petition.
In his read petition, my lord, we were not made right.
No,
For a moment.
They were made a party.
yes,
They were made, yes, 6, 7,
6, 7,
8,
8.
9, and 10.
Yes,
Yes, they made us. But
The-
we were
the
not heard even.
petitioners. These 6, 7, 8, and 9 are all read petitioners.
All read petitions.
Were added as party respondents. It is futile to observe by now that the petitioners were also added as respondent in the writ petition with 280 of 2018 or to have been directed to be heard. This time, however, since the respondents have already considered the matters and issued passed the impugn order. No blame can be attributed to the respondent authority in a strict sense. Understand? However, it is however, evidently no opportunity of hearing was afforded to the petitioners. Which is a violation of a cardinal principle of natural justice. Mr. Having considered that the petitioners were not given an opportunity of hearing before passing the impugned order, this court would not go into the merits of whether the work orders were issued legally or not, which would be decided by the competent, the concerned, competent respondent authorities for the reason that, in this court would propose to pass the orders infra, within bracket infra. Mr. The Mr. As fairly submitted by the learned counsel for the respondents. In the facts and circumstances of this case, and having been held above that the petitioners were not given an opportunity of hearing from the deem it appropriate to remand the matter back to the respondent authorities, particularly the Secretary WRD, to have a fresh consideration after hearing the petitioners as well as after giving an opportunity of hearing to the petitioner as well as the respondents. It is also, this court would not also embark on the disputed issue of whether, would not embark into the disputed issue of whether the petitioner has completed the works or not, or and also as to whether the status report was issued by the concerned officials under duress. List of next para. Having in view of the above discussions come up, I'm of the considered view that the impugned order dated 10/10/2018 passed by the WRD page 28. Is it page 28? Secretary cannot be sustained as the same has been passed without affording an opportunity to the affected party, particularly the petitioners. Accordingly, the impugned order so is set aside in past. However, no, please stop. However, the matter is remanded back. How about that?
Not remand back because
What do we call it? Not remand back,
it's not remand back because
remitted back.
there is a judgment I remember, if the same authorities have taken a decision, then remanding back would again prejudice the right of protesters.
No, we're not, there may be the change in the circumstance, maybe put option, it's okay.
Yeah.
However, the matter is remanded back to the respondent authorities, particularly the Secretary, WRD, Government of Arunachal Pradesh, to decide the matter afresh, after affording an opportunity of hearing to the petitioner as well as the respondents within a period of 2 months from today, 1 month,
That, may I just make a request?
preferably within a period of
Sure.
2 months from today. List of. That's why I wanted to know from the government, is it any surviving thing? It's in SIDF. Will it continue? Anyway, you fight it out.
Well, that last part, if I may allow to make a request.
Which one?
Last sentence.
Which one?
Is
To
yes,
decide the matter.
to decide-
Remanding back.
Yes,
It has to be decided. See, reason is very simple. Suppose if you are entitled, tomorrow, if it is found that by now, by lapse of the time, if you are found to be completed, you have a right to claim for the thing. If you are not found to be, if you have not done the work, if they want to continue the, I mean,
that is fine. But-
in that case, you have also a remedy
Yes, yes,
to file damage, whatever is there.
correct, correct.
But we are not blaming the respondent authority of not hearing you. Because the order of this court
Was not
is only to the respondent, petitioner.
petitioners.
Though you were also made party. That's the reason why we are interfering.
Yes.
That's why I'm saying, cannot blame the authority in the strict sense.
Well, can we add one line?
Which one?
Only one line, the work completed. The petitioner shall be.
No, that I will say, will not embark, this court will not embark upon the whether to the issue as to whether the you have completed the work or not.
Okay, okay, ma'am, being disputed question of fact. Correct, correct, ma'am. Correct, ma'am.
I
Great-
said,
great,
will not
great.
embark on this.
I
That will be all decided by
Yes.
the,
This is for you, just I indicated all.
in,
the
in
packages
view of,
and,
you know, the, with the above observations, directions, the writ petition is disposed of.
Grateful.
Yes, my lord.
Yes.
My lord.
My lord, this is a criminal petition, my lord. This petition is basically filed against the order passed by a lauded Session Judge, Consa, whereby the earlier way, which was granted by the lauded
Executive magistrate.
JMFC. He was al-
Executive magistrate.
Yes, executive magistrate, but he was assigned with the power of the JMFC. There was no JMFC, regular
Yes.
JMFC at that point of time. Now, my lord, I am challenging the order, bail cancellation order of the London Session Judge on the ground that since it was a revision petition filed by the IO of the case to cancel my bail, which is
It's not appealable, I mean, the order to be
yes,
ordered for revision.
yes,
Why?
Because bail is granting of bail and rejection, my lord. It is an interlocutory order against which no revision can lie. That is the
Main point.
settled law. Yes, I have placed some judgment in the other occasion also, my lord. Today, my lord, should I narrate the brief background of the case, or should I straightway argue on this law point?
What facts did require this? What facts? What is the offense involved?
Offending
You
involves.
start the facts and then
Yes.
come to the law.
Yes, my lord. My lord, in fact, the petitioner, he is a government employee, serving in the Department of Skill Development and Entrepreneurship,
Yes.
in the capacity of instructor. While he was posted at Changlang, his particular place of posting is within the district of Changlang, but Karsang is the particular place, my lord. He was posted there as an instructor of the said department. So while we posted here, one complaint was lodged by a person namely Chandru Tanti, saying that this data is missing. So in the due course, a case was registered that girl, it was found from Nahaldagan. And so a case was registered against the petitioner.
I'll give you 5 minutes.
Yes.
You complete the facts.
Yes.
And the law 5 minutes.
Yes, he was this case was registered and he was charged under section 363. And accordingly, he, after the registration of the case, he moved a bail application before the session judge, Konsa. It was rejected. Again, the petitioner came before this honorable court. This honorable court also rejected the anticipatory bail application. So, finding no alternative, petitioner surrendered before the JMFC, Changlang, and on his surrender, bail was granted. Granted on 11/3/2000.
Before the same executive magistrate.
Bail was granted by this executive magistrate only.
No, surrender also.
Yes, I surrendered before him. So on the date of date when I
Before the
surrendered before,
separation.
my lord.
Before the separation.
Yes,
There is no judicial magistrate first class.
there was, in fact, he was in leave at that point of time. So why this executive magistrate was given the charge of JMFC. So he has not granted the bail as an executive magistrate, my lord. As a JMFC has granted the bail,
What's the authority?
my lord.
You are executive magistrate, but how you can act in a judicial magistrate first
My
class?
lord says the regular JMFC was on leave, so he was given the charge, my lord.
In a peculiar circumstances
Yes, my
of the
lord.
case.
No, my lord,
Otherwise, normally,
No.
no charge can be given. Can
no,
this court give my charge?
my
when I'm
lord,
on leave
my lord,
to the deputy commissioner or the commissioner
my lord,
or the chief secretary?
my lord, this court will be adjudicating the power of the session court. If he can reject,
Before that, we'll also examine the power of the executive magistrate. How can he act like a judicial magistrate? He's an executive magistrate.
he was
He has certain limited, he has certain authorities.
in the absence of regular.
How the
JMFC, my lord.
judicial magistrates are appointed?
If my lord, that is not my case, my lord. If my lord is this,
We'll bring this to your case. We'll understand how can the executive magistrate can grant a bail.
not
It's,
in the.
it's
my lord,
a void.
My lord, I am repeatedly making a submission that while granting the bail, my lord, he was acting as JMFC, my lord.
How
not as
can he act
executive
as a
magistrate, my lord.
JMFC He's an executive magistrate.
He was
You are,
given,
as an executive magistrate, you have a limitations. And your authorities are limited. You cannot act as a judicial magistrate.
because
Then what is the difference of executive magistrate and judicial magistrate?
the place is of course dear, my lord. Of course, dear, my lord. And
You
my-
may say, under the peculiar circumstances prevailing in the state at that point of time, and the state being nascent state, having no regular separation of judiciary from executive, things were allowed. That we can understand, because it's a practical problem. But after the separation, how can the charge be given? And how can you act like a judicial magistrate? You act as a executive magistrate, that's all.
wrong-
Anyway,
yes,
proceed.
wrongly or rightly, my lord, I was
Granted.
given that I was granted by the
So it was not the ground for cancellation.
no, my lord.
The
It was
ground
not the
was-
ground of cancellation.
What
my
is the ground of cancellation?
ground of cancellation was that, my lord. My lord, may kindly come to the order passed by the,
Yes, you come to it, come straight. We'll not go all those. Where it is?
my lord, page 14.
14,
No, my lord.
40.
Okay.
Your 10 minutes, 5 minutes is about to lapse.
My lord, I'll,
Are you ready or not?
I am ready, my lord, I am ready,
Yes,
but
if
my
you are
presentation
ready.
is big, my lord. My lord, may now kindly come to page number 22.
22.
Yes, my lord. This was the bill granted by GMFC, my lord. And my lord, the order, impugned order,
Page 33.
yes, it is page 33, my lord.
It's a long order.
Now, my lord, kindly see, my lord. Firstly, the cause title, my lord. How this case was registered. This is criminal revision, my lord. Number 03 of 2020,
Were you hurt?
my lord.
Have you been hurt?
No, my lord. I was not hurt. Only on the insistence of the IO, my lord, this order was passed, my lord. While passing this order, I was not hurt. When I was not summoned for this hearing of the matter, my lord. My lord, may I read the impugned order, my lord?
Hmm.
It is very long order, my lord. The relief, because we shall have to find out, my lord, what was the ground, my lord, for rejection of my cancellation of my bail, my lord. So therefore, I need to read the whole order, my lord. To the criminal division case number so is fixed for judgment and order. The state is represented by so. Accused person is found absent. However, he is represented by learned person, Mr. So. I have heard argument put forward of the learned person for either side. Present criminal revision is registered by
You
way
come
of
to page 40.
page. Page 40.
Yes, you read these 3 paragraphs.
I have perused the record of a case and seen that after registration of present criminal revision, white number so notice was issued to the accused Daja Nimpo for his personal appearance before the court. And so opposed as to why the bail granted to him by executive magistrate Changlang should not be cancelled. I was also specifically ordered that in default in personal appearance so caused by accused Daja Nimpo before this court, the bail granted to accused will be cancelled without any further correspondence. But respondent accused Daja Nimpo has never appeared before this honorable court till date. It is observed from the record of the case that the respondent accused while filing bail application number so has concealed the fact that his anticipatory bail application was rejected by the High Court as well as this court. Such concealing of material facts shows that the accused representative has misled the executive magistrate or otherwise as per the judicial property when a bail application is rejected by different high court, higher courts, the subordinate courts should not allow the same. On the other hand, the executive magistrate has not called for the case diary, nor has he sought any report from the investigating officer regarding the status of the investigation. Learned the executive magistrate has not even heard learned PP before granting bail to the respondent accused, which is mandated under the law. In view of entirety of the case, it is found that the bail order number so is passed by executive magistrate Changlang is in violation of established procedures under the law, and the same is passed as the respondent Dajan Info has misled learned executive magistrate by concealing material fact and misrepresenting. Hence, the order of bail that is so and so passed in bail application number so and so by executive magistrate Changlang in Karsang PS case number so and so. Whereby if Dajan Info was allowed to go on bail is then set aside. Send back the case record of bail application number so and so. This case is disposed on conference given under my signature. My lord,
Continue it to.
my lord.
Yes,
My lord, whether executive magistrate can perform the duty of judicial magistrate, that is not the issue in our case, my lord. My case starts from the moment when the bail granted by the judicial magistrate first class was cancelled by the district and session judge also. How it was cancelled, my lord, that is the issue in this criminal revision petition, my lord. Rightly or wrongly, my lord, the executive magistrate who was invested with the power of JMFC, my lord, he has granted me the bail, man. That bail, of course, can be. I am not saying that bail cannot be.
we'll go into the foundation, not only the structure.
Even in the foundation, also, my lord. The learned court below who has granted me the bail has committed no error, my lord. If that error is to be rectified, my lord, there is a provision, my lord.
Yes,
provided
tell
it-
us on what ground your bail has been cancelled.
My lord, how it was cancelled,
You have been given an opportunity. The nomenclature of the petition doesn't make any difference. It was for cancellation, right? There is an application.
that is there, my lord. But
You have considered that your anticipatory bail has also been rejected.
no, my lord, that was
That
not
is
the
the reason the foundation will have to go into the foundation. Executive magistrate.
my lord.
I'm not undermining and I'm not doubting. For a moment also, I'm not doubting the competency of the executive magistrate. But then,
My lord,
Yes.
when, my lord, I have already surrendered before the learned court below, who has granted me the bill, my lord.
court below what? Executive magistrate?
Yes, my lord. There is no point, my lord, to tell or this.
You, according
the
to,
executive magistrate, that
according to you, what is the ground of cancellation?
Ground of cancellation, my lord, yes. In the order, my lord. This notice was not issued the PP. And there was no PP while this bail was granted. My lord, that is also a ground, my lord. I do fairly admit, my lord. But that can be, my lord, my bail granted by the learned court below, my lord. JMFC, my lord, that can be set aside by invoking proper provision as provided in the CRPC, my lord. The proper provision is, my lord, section 439(2) of the CRPC, my lord.
Yes.
Whereby it has been provided that, my lord, the session court and the high court, my lord, on application made by the PP or the party, my lord, it can cancel the bail, my lord. That is
So
the,
admittedly, it's not a form, there's an application for cancellation.
so, my lord, if the application for cancellation, my lord, it was filed under 439
Hmm.
2 as 2 of the CRPC, my lord, I would not have approached this honorable court, my lord.
Hmm.
So, my lord, since my only case is that this granting,
And your bail, you have been granted bail by the executive magistrate
yes, my lord.
without issuing a notice to the PP.
Yes, as per the order passed by the.
So you agree to that? That ground is sufficient to cancel.
But not by this invoking
Revision
the-
petition.
the
That's what I'm saying, form, it's a form. Let us not go by the form, let us go by the substance.
Since my lord, no,
Substance is, there is an application. And you have been issued a notice. You refused to appear, right? You didn't appear even after.
no, my lord,
notice.
the effect of the case is that, my lord, after I was granted the bail by the JMFC, my lord, on
Say executive magistrate holding the charge of JMFC. Don't say JMFC.
since my-
Saying the executive magistrate as JMFC will not impress on this court.
my lord, that is not my case, my lord. I am not saying that, my lord, this of course, my lord, as per the order,
We'll
my lord,
bring it,
it is
we'll
executive
bring it.
magistrate, my lord.
We'll look into how your bail was granted.
That
Who has granted your bail? What manner the bail was granted? Was it in accordance with law?
yes, my lord.
Yes. So we'll not hear you on the basis of the form, we'll hear you on substance. So tell us what's wrong.
My lord,
Be specific.
in fact, my lord, these issues, my lord, I, in fact, had gone through a judgment, but today is my, my lord is aware that my case wholly depend on how my bail has been cancelled on the basis of that.
Yes, tell
my
us,
lord.
we'll consider.
Now,
We'll consider, tell us.
since, my lord, I have not brought all those judgment, my lord. Because
That's why initially I asked you, is it for disposal?
my lord, may fix the matter the next week, my lord. Because I will be placing some judgment on this, how I.
We'll find out the judgment, you argue. We'll find out. We'll allow you to place by evening. 5 o'clock I'll allow, till 5 o'clock.
My lord,
All right. Can you place it?
No, my lord, I will have to charge all those judgments, my lord. It is not readily.
No, I am not, I'm hearing you, I have not determined. I don't prejudge. And I am yet to hear him also. Hear the PP.
My lord,
If you genuinely feel that you will not be able to, convince this court, will grant you, but only for the judgment, we'll find out the judgment, what's there. Do you have net in your mobile?
my lord,
Do you have a net in your mobile?
yes, my lord, I have.
That Jetfall 5, something like that. Jetfall 5.
No, my lord, I have.
You have a lesser version.
Yes. I can't afford that this. My lord, my lord, can I say, my lord, bail application wise, can we come to page number 22, my lord?
Yes.
Once again, my lord.
Heard Mr. D. come to learned counsel for the petitioner. After arguing a matter at some length, Mr. Kamduk, learned counsel for the petitioner, pressed for 2 days time to what? 2 days for what?
My lord, may say, my lord, I am not fully prepared today, so I am seeking adjournment for.
Tuesday's time
Not only my lord, let it-
press for press for adjournment for 2 days. As according to him, he's not fully prepared. Mr. T at the London additional PP is present. List on after 2 days, 14.
I have a difficulty, my lord. Yeah, okay.
Then tomorrow,
Can it be next week, my lord?
either 13 or 14.
Let it be
I've
on-
not heard you.
Let it be- let it be
Let
on
me have the
14 then.
privilege of hearing you. 13. Day after.
Obliged, Your Lordship.
But on that day, if you are again not prepared, I may grant you, but you have to appear, not through your brother.
I surely appear, my lord. I assure this honorable.
Then
court.
if you have a problem on 14, 13, day after.
Yes, yes, my lord.
My lord, this is a criminal petition and today is fixed for admission. Since the
Yes.
leading counsel is out of station, so matter may be fixed for tomorrow.
Donna. What is the offense?
It's 376 and 509.
Basically, Your Lordship,
On merit?
yes, on
not on
merit,
competence.
on merit.
Very difficult, madam. 376.
Otherwise, Your Lordship, if we go through the record, subject to correction, Your Lordship, they were perhaps in relationship. All this aspect has to be taken into consideration.
What?
They at least to have been in relationship, Your Lordship, as per the record, Your Lordship. This is the subject matter to be adjudicated by this court, Your Lordship.
So you are,
I'm for respondent material.
are you ready?
You are a leading counsel, and having his out of station, so let me instead next week and
On the joint prayer of London Council for the petitioner and respond number 2. List this matter after
So tomorrow,
a week. You said next week.
Obliged.
Mr. T as the London additional PP is present. Yes, sir.
As per last order, updates will be of control, but not.
Why? Have you contacted? Have you sought for the updated?
Yes, so the materials.
So. Why are you trembling? What's wrong with you? Why are you trembling?
Feeling not so well.
Not feeling well,
Yes.
but looks fresh. Absolutely fresh. About chewing Tamil.
No,
What do you chew? What do you take? Nothing. Heard, Mister?
E-Pine, Your Lordship.
Buying
Buying.
London Council for the petitioner. Give it. Also heard Mr. G. Thado, London Council. London additional PP for the state. This court on 24/05/2024. Has directed has adjourned the matter for updated case diary. Mr. However, today, Mr. G. Tado, Learned Council, Learned State, Learned Association PP submitted despite intimation, he is yet to receive. Despite intimation sent to the concerned IO, concerned IO, we have sent it OC to the concerned OC police station, he has not received the updated case diary for which
FSL report.
for which he prays for 2 weeks, a week's time.
2 weeks.
Prays for 2 weeks' time. Just to praise the Lord. This is after 2 weeks. Have you appeared?
Yes, Your Lordship. Yes,
Have you,
yes,
statement has been recorded?
yes, statement has been recorded and we have also handed over our telephone.
FSL for what?
FSL for determination of mobile
Okay. Okay.
and contents.
Okay.
Deeply obliged.
Yes,
Lordship, I have filed wakalatnam on behalf of respondent 1, 2, 3, 4, 5, 6, 7 and 14 and 16.
yes.
The rest,
What about others?
Lordship, I'm unable to get in contact with the rest.
Huh?
I'm unable to get in contact with the rest.
As per the lower court record, madam, they were representing all the respondents,
Who?
one advocate.
Mr.
But
Gatso,
not Gyatso, madam.
who?
The respondents, they have together, they have appointed only one advocate. But
So do you
now,
take-
as of now, they are,
so you take pressing steps in that case?
but since the service report upon,
Huh?
there are 12 respondents, madam.
Yes.
Means,
Who else are not represented?
uh,
Service is completed.
as of,
Is service complete? There's nothing to. Office note doesn't reflect anything.
office note reflects that only for few the service has been completed.
Who else are not represented? You take pressing steps. Or Mr.
S. Chetri, madam.
S.
S. Chetri.
Sekia.
Chetri, madam.
Chetri, okay. S. Chetri, Learned Counsel for the petitioner. Appellant. Mr. G. Gyatso.
T. Gyatso.
T. Gyatso, sorry. Learned Counsel. Appears for respondents number, respondent numbers 8, 9, 10, 11, 12, 13, 15, 16, 15, 17 to 21. Who else are not represented? Who else remains?
8, 9, 10, 11, 12, 13, 15, only this 17 to 21, madam.
7, yeah?
8, 9, 10, 11, 12, 13, 15, 17 to 21. They are not represented.
You are not representing them.
No, I'm representing for 1, 2, 7, 14 and 16.
Enter appearance on behalf of respondent 1,
1, 2, 7,
1, 2, 3, 4, 5, 6, 7,
14 and 16.
14 and 16.
Yes.
Then who else are there? Remaining?
My lord, 8, 9, 10, 11,
The Learned Counsel for the appellant is permitted to take fresh steps for service of notice upon respondent number
8, 9, 10,
8, 9, 10,
11,
12,
12,
13,
13, 15,
15, 17
17
to
to
21
21.
within 3 days.
My lord,
List after
there
4
is
weeks.
interim order, my lord. It
Interim
may-
order pass earlier shall continue.
Obliged.
Your Lordship, the petitioner were directed to take steps upon respondent number 4. Perhaps Your Lordship, service is complete.
Hmm?
Perhaps service is completed.
Okay. Four to nine
Yes, 4 to 9, Your Lordship.
only,
Yes, Your Lordship.
non appears for the petitioner also. This
4 to 9.
Mr. Theatre Learned Edition PP is present. Service report, no. Office note indicates that the service in respect of respondent 4 to 9 is completed. List the matter after 3 weeks
Your Lordship, maybe for admission hearing.
for admission. This after 3 weeks for admission hearing.
Okay. Deeply obliged, sir.
May I, Your Lordship?
Yes.
Lordship, I appearing on behalf of HR Obing. Due to some difficulties, Your Lordship, he is unable to attend court today. Your Lordship.
You are for
Uh,
petitioner.
yeah, my lord, I am from the respondent number 1 to 16.
Your Lordship, I am for petitioner on behalf of Subu Koyan.
Mr. E. Payeng Leonard, consent for the petitioner. Leonard Counsel appearing on behalf of Leonard, Mr. E. Payeng Leonard Counsel appears for Mr. S. Koyang, Leonard
Yes, Your
Counsel for the petitioner. Mr.
HR Obing, Your Lordship.
You are your name?
K. Moses.
A.
K. Moses.
K. Moses.
Yes, Lord.
Leonard Counsel appearing on behalf of Mr. H.R. Obi, Leonard Counsel for the respondent number 2.
Well, respondent number 1 to 16.
Respondent number, private respondents,
Yes, Lordship.
respondent number 1 to, sorry,
One is state.
2 to 16.
Yes.
2 to 16.
2 to 16 submits that the leading counsel, in this case, Mr. H.R. will be indisposed today for receive report listing the matter after 3 weeks.
After 3 weeks, yeah.
After 3 weeks.
Oh, Lordship.
Praise the Lord. This after 3 weeks. Mr. Gita, then additional PP is present. Yes,
Highly obliged.
Deeply obliged.
yes. Yes. What is
Here in
the-
item number 19, Lordship, the respondent number 4 and 5 are yet to file their objection, Lordship.
Who is for respondent?
I'm for respondent number 4 and 5, Lordship.
Yes,
Lordship, we would like to request this honorable court to kindly give us some more time to file objection, Lordship. 3
Not
weeks
Mr.
time may be given.
under counsel for the petitioners.
Petitioners. Not petitioner, Lordship.
Miss MS, also MS L Hage, learned additional PP for the state. Miss Miss MS
Timo Sang,
T. Mosa, learned counsel appearing on behalf of respondent number 4 and 5. Respondent is granted 2 weeks, further 2 weeks time to file objection.
Lordship, interim is there.
After 2
Interim is.
weeks.
Interim is.
Interim order was let's continue.
Item number 20, Lordship, same analogous matter.
Obliged.
Your Lordship.
Yes,
Your Lordship, service report in respect of respondent number 2 is still awaited. I'm allowed to take first.
await service reports list after 3 weeks.
Your Honor, there is an interim that may be continued.
Interim order as per, first earlier shall continue.
My lord, as per the last order, I have filed the additional affidavit.
Affidavit,
Yes, Your Honor.
what is the affidavit? What affidavit?
Swearing by the,
On behalf of
on behalf of petitioners,
Hmm?
swearing by the petitioners of number 1 and 2.
Where it is? Where's the affidavit?
Your Honor, my lord, I have filed through registry.
Where it is? Your additional affidavit.
Sorry, my lord, IN number 42,
Hmm?
IN number 42,
42.
42, IN number 42 in criminal petition 2000.
Yeah,
2022.
additional affidavit is there. Where is the affidavit? Find out. In IA, why you have filed that additional affidavit?
As per last order, my lord, petitioners has to be jointly swearing and file before this court. For crossing and set aside of the operation pimpin charge sheet number 199.
It should have been separate affidavit. Why joint affidavit? Why you have said additional affidavit?
Sorry, sir. Sorry. Your Lord.
It should have been separate affidavit. Anyway. Heard Mr.
Kel Takam.
El Takam. Takam,
Yes.
learned counsel for the petitioners. Also Mr. Jitado, learned CPP for the state. The petitioner, the learned counsel for the petitioner said, while an additional affidavit, bringing on record the joint affidavit sworn in support of the criminal petition. While an additional affidavit, placing on record the joint affidavit, right? While on behalf of, sworn by the petitioners,
Yes.
both the petitioners,
Petitioners, yes, number 1 and 2.
petition number 1 and 2,
Yes.
in support of the in support of the connected criminal petition number. What is this number? Triple 23, huh? Same is taken on record. List the matter after 3 weeks.
Okay, yes.
2 weeks or 3 weeks?
2 weeks, yeah.
2 weeks, huh?
Pavlovich.
Average service report, list after 3 weeks.
License.
Average service report, list after 4 weeks.
Aloshi, there is the interim order.
Interim order plus earlier shall continue.
My lord, this is joint application, my
But
lord. joint
Mr.
petition.
We come to learned council for the petitioners
Petitioners.
and Mr. Theatre learned addition PP for the state. LCR is received, the trial court record is received, list for admission hearing.
My lord.
After 2 weeks. 2
My
weeks.
lord, yes. My lord, there is interim order, my lord.
Interim order plus earlier shall continue. Yes, sir.
Impugn order, my lord, will find it page number 84,
54,
84, my lord.
84. If you have some work, you may go. We'll call you. We'll take time. Yes,
Okay, my lord, from this, my lord, will see, my lord. Case here is, my lord, I was issued transfer order, my lord. Now, I immediately did not comply with that transfer order, my lord. I tried to get some redressal, my lord. Yes, my lord, I was suffering from, my lord, some type asthma, my lord, that is high peak altitude illness, my lord. Accordingly, I try my best, my lord.
4 months. 4 months.
My lord.
4 months you were there. You did not join.
My lord.
You should be happy. You have been retained in the service.
That is true, my lord.
You have not been dismissed.
No.
You should be happy. That too, even on appeal, appellate authority has modified the penalty. Be happy. Dismissed.
My lord,
What is the violation?
Violation, my lord,
Factually you are not.
other
Factually you are not, will not be,
violation, my lord, I am saying, my lord, by this, my lord, impugn order, my lord. Two punishment is imposed, my lord. One, my lord. This is one, my lord. This is
That has been modified.
modified, my lord, but modified, but
Will upheld the appellate order
no, my lord.
where it is.
Page number 85, my lord,
No. This is by whom?
by the disciplinary authority.
Huh? Penalty of reduction to lower time scale of pay. Hmm? Can it not be done?
That can be, my lord. Now, additionally, my lord, down below, my lord, part
It's
of his
not a penalty.
period of absent from duty is treated
This
as non.
cannot be a penalty.
This is, my lord,
Is it a penalty?
penalty, my lord. For the same period, my lord. So same period, my lord. My absent, I have given punishment, my lord.
If you are penalized for this thing, how can this will be contradictory? If it is treated to be on duty, right?
Oh,
This is the main allegations.
my lord.
Main charges is this. It has been proved, right? Charges have been proved.
My lord. Additionally, my lord, I am saying, my lord,
Unauthorized absence from duty.
yes, my lord. Additionally, I am saying, my lord, there is a violation of Rule 7, my lord, clause
7.
12, my lord. I have been not given a chance to cross-examine a prosecution witness, my lord.
What improvement you can give if you are cross-examined? You are admitting that.
No, my lord, I have not admitted that why, my lord.
Otherwise, the facts remains. It is a admitted position, facts, that you did not join.
Yes, my lord. I did not join by whether, but that was not with any ill intention, my lord. I tried, my lord, to avail, my lord, all the remedies, my lord, available to me, my lord, in terms of the rule, my lord. I approached the authority, my lord.
What's the order of the appellate authority?
Appellate authority, my lord, will find it.
Affirm that. That's all.
Page number
94. 94.
Yes, my lord.
Reduce the impute penalty of reduction to lower time scale of fees to that of withholding of 2 increments which cumulative for a period of 2 years. Yes. You are a police personnel.
My lord.
Your appellate authority is so nice of you.
With discipline, my lord, I have served the police authority already for 32 years. 32 years, my lord. At this age, my lord. At this age, my lord. After
You remain unauthorizedly for 4 months.
that is true.
More than 4 months.
Now, but after that also, my lord, when I joined, my lord, yeah, my this though in terms of medical report, my lord, I was found fit, my lord, to join the army. After joining in 2 months, my lord, I have taken transfer back, my lord. Yes, my lord, I was suffering from
If
that.
you are found fit to work there, then
My humble assumption, but at least, my lord, I may be allowed to proceed against the prosecution witness, my lord. That is a part of the procedure, my lord.
where is this? Where is the rule? Show us the violation of rules.
Rule, my lord, this is Arunachal Pradesh Police Discipline and Appeal Rule 1999, my lord.
Have you annexed that?
No, my lord, I have not.
Have you annexed that?
Not annexed, my lord, but I have mentioned the provision, my lord.
Yes, this is the only ground, para 16. Para 16
My lord,
of your writ petition.
16, my lord. I have. My lord will kindly have a look at, my lord, the inquiry or report, my lord, by which, my lord, I have penalized, my lord. That my lord will find it, my lord.
Page
74, my lord.
inquiry report.
My lord, this is the inquiry report. Acting on this, my lord, this impugn, my lord, the order was passed, my lord. Page number 75, my lord, will see, my lord. Point number 7, my lord, such that was not admitted or dropped. Article has not admitted the such level against the him, hence no such was dropped and an inquiry proceed further. Such actually inquiry into, my lord, since the observed and not admitted such, hence the inquiry was proceeded further on the basis of article of such number 1. Witness, examination of witness, my lord. 10, my lord, statement of DYSP such and such. During the course of inquiry, such and state that the authority has directed to continue into such a platoon company to for the detailment of post wherein head constable such and such of first I will his name was also listed among other 12. Such and such, the order was served to such and such after a city received command certificate to proceed to platoon for the further duty. Statement of such and such. Now here, my lord, my lord, I was never given a chance to, my lord, proceed against those witnesses, my lord.
When was the report, this report?
This is the report of the inquiry officer, my lord. By which, my lord, on acting on this, my lord, this penalty was imposed by me against me, my lord.
Have you received the inquiry report?
My lord, this is inquiry report, my lord.
You have received this?
Yes, my lord, I have received.
You have been furnished with?
I was punished with it, my lord. I was punished with it. I submit even written statement, my lord, against this, my lord.
Okay. Where's your statement saying that you have not been allowed to cross-examine?
I think, my lord, in written statement, I have missed that point, my lord. Written statement, I have missed that point.
What was the writ petition against the transfer?
My lord, against the transfer.
64.
My lord.
Writ petition
My
64.
lord.
An appeal you have, in appeal, let us see your appeal.
Appeal start from, my lord, page number 86, my lord. 86. At page number 90, my lord, last part I have mentioned that, my lord, in appeal, my lord.
90.
Page number 90, my lord, this is part of the appeal, my lord. Last part I have mentioned that, my lord. Violation of other rule is there, my lord, but I'm not pressing today, my lord, that also other rules, my lord.
Huh?
Other rules mentioned here in my lord, I'm not pressing that, my lord.
What
Rule 1
other
key, my lord.
What other rules?
That mentioned here, my lord, rule 715 mentioned 12 1K also mentioned, my lord. 1 IJ, my lord, I'm not pressing that, my lord.
You are pressing on what?
Rule 7 sub rule 12, my lord.
What is provides for? What it provides for?
It provide for, my lord, to allow to examine and cross-examine the witness.
Any judgment?
Judgment today I have not brought, my lord. Judgment I have not brought, my lord.
Otherwise you have.
Not brought.
Huh?
Judgment, my lord, I did not brought, my
You don't have.
lord. Not have.
You have not looked into.
I have, my lord, some
You find
judgment, my lord.
Not providing an opportunity to cross-examine. Will it be fatal? Will it vitiate the proceedings?
No.
This is the only ground. Right?
Yes, my lord.
So according to the rule 712 only,
My lord.
not allowing to
712, my-
cross-examine.
My lord. In addition to that, my lord, two punishment I am saying, my lord. The punishment prescribed under the rule, my lord, is
No, it's not a punishment. Second one is not a punishment.
maybe, my lord, but my submission, my lord, is, my lord, there's a specific rule, my lord, saying this can be the punishment.
This is the basis of your punishment. So whether to consider or not, treated as spend on duty or not, it's up to them. It's the basis.
Basis.
It's not amounts to double punishment, double penalty. That is rejected. Only issue is whether not providing an opportunity to cross-examine vitiates the entire proceedings. Yes, yes.
Lordship,
Para 16, what is your reply? Para 16
no, Lordship,
of the writ petition.
here, he have been participating from the beginning, Lordship. So he could have taken up the plea there itself only, because as per the records, a record was also called for. In each and every statement, his signature is there, and the other witness signature of the witness is also there. He could have raised that point at that relevant point of time. He did not say anything. Even as per the record, he was offered defense assistance also, but he declined. So therefore, he cannot claim that benefit after all this happening.
He have waived his right.
Lordship,
He has waived his right.
Lordship.
What is this? Para 16, para 16 of the writ petition. What is your reply?
Para 16, Lordship, our page 8, para 13 also.
Hmm?
Page 8.
2, 3, 4 and 2, 3 and 4. Affidavit of opposition.
Lordship.
Yes. Para 8.
The insuring deponent admitted to extend that petitioner preferred an application dated such and such before the DIGP OPS.
Para 8.
No, Lordship, page 8, para 13.
Yes.
With regards to the statement made in para 16 of the answering respondent admitted to extend that the petitioner preferred an appeal application dated such and such before the DIGP Itanagar against order wide number such and such dated such and such passed by the commandant first APPN battalion headquarters imposing him the penalty of reduction to a lower time scale pay, further treating his period of absence from duty with effect from such and such as not spent on duty. The appeal of the petitioner was examined in the light of departmental inquiry record. The inquiry found to be have conducted as per procedure led under Rule 7 of the APP under bracket DNA Rules 99. The petitioner first participated in the inquiry proceeding from beginning to end. He put his signature on the statement of PWS. He could have cross-examined the PWS at any point. Examination of court witness is not mandatory provision. There is nothing to clarify. Moreover, the petitioner did not mention as how he was prejudiced by not examining court witness. Further, the requirement for so cause of notice is mandatory only in case of proposed penalty that is of dismissal or removal from the service as per 13.5 of the APP DNA Rules 1999 also.
Yes, all along you were there.
Yes, my lord.
You have participated, you have put your signature.
Lordship, even the original record was also called for by this honor.
Where it is.
Lordship. It's
You have that.
Yeah, my lord. They are saying, my lord, I participated, my lord. With my humble, this is
Participated and you have been given the defense assistant also, you refused.
no
And every statement, your signature is there.
my lord, my lord, yes, my lord.
Every deposition.
Defense assistant, my lord, yes, my lord, that may be declined, my lord. But ever, my humble understanding, my lord, to say, my lord, my sign is there at the statement, my lord, repenting, my lord, to give me opportunity, my lord. Ultimately, my lord, I am not a legal expert, my lord. I was, when the rule prescribed, my lord, rule prescribed for cross-examination, my lord, it is mandatory, my lord, to say whether I like to cross-examine or not. That should be the record, my lord. Simply, my lord, putting, my lord, my signature in the record, my lord, cannot be said that, my lord, this procedure, my lord, mandatory procedure, that to be to impose a major penalty, my lord, was compliant, my lord.
So again, you show us the prejudice caused to you.
Prejudice, my lord, to that extent, my lord, yes, but that maybe not, my lord.
Because of
But my humble submission, my lord,
not giving you an opportunity to cross-examine. That's why from the very beginning, I'm saying, how could you, what, can you demolish that you had not spent on duty? I mean, you have not, did you not join? Whatever may be the reason, 4 months you have not been there. You have not joined.
well, there's a thin line, my lord. Thin line is, there is a procedure, my lord. The statutory author need to act on that procedure, my lord. To say, my lord, I put signature in the support in the statement of the witness, my lord. There is a record.
Are you saying that your signature was taken by force?
No, my lord, I am not saying
Then-
that. To my lord, giving, my lord, once there is a statutory provision, my lord, that is a part of natural justice, my lord. That's why that provision is there in the rule, my lord. When that is there, my lord, it is the duty of the statutory authority, my lord, to give that opportunity to me, my lord.
No, tell us if you have been given cross-examine,
My lord.
what more improvement you can could have brought in on the facts of the case.
My lord,
Can you improve that you were not You were there in the transport place. Can you bring that facts by cross-examining?
No, my lord, about the merit, my lord, surely, my lord, I may be not demonstrate, I'm not be able to demonstrate that, those aspect, my lord.
Yes.
But my humble today, my lord, these people, this is my comment.
I
When
think very lenient.
there's a problem,
Appellate authority is very lenient to you, including disciplinary authority. It's a case for dismissal,
no, my lord, that,
not even removal, dismissal, 4 months.
Four-
You are a police
my lord,
personnel.
no, my lord, that was with some, my lord, on report, there is some difficulty, my lord. My child, my lord, has so illness, my lord, epilepsy, my
That's
lord.
the reason, if you are not interested, if you cannot follow the thing, then you can quit
But
the job.
I'm
There's no
interested.
bar.
I'm interested, that's why, my lord, I already served the police department for 32 years, my lord. Today, my lord, my humble son people, my lordship is my lord. I am saying, my lord, when there is a rule, my lord, to total compliance of the rule, my lord, is raised upon the
Let us see the
who exercising,
rule.
who
Where is
exercising
the rule?
power under those rule, my lord.
The witnesses shall be examined and may be cross-examined on behalf of the charge officials. The inquiry authority may also put such questions to the witness as it may think. Maybe examine and examine. You are there. This is the reason I'm saying.
Yes,
It's
I-
not that you have been not allowed to completely cross-examine. All along you have participated.
Right.
Every statement was made before you. A deposition was taken, recorded before you. You have not said anything.
Yes, ma'am. That time, my lord, I'm a layman, my lord, the statute authority, my lord,
Don't you have?
cannot.
Huh? It may have been.
Only my submission would be, my lord. If my lord simply,
Dismissed.
simply, my lord, only one line submission, my lord. My lord will kindly perish the record, my lord. If in the
It
record,
is
my lord,
not mandatory also. The word is still maybe.
my lord,
Had you,
my lord, no, my
had
lord,
you not present at the time of deposition of the witnesses, matter would have been different. That
My lord,
you
no,
have
my-
not been allowed to, I mean,
my lord, no, my lord. Interpretation of maybe, my lord. Sometime, my lord, when, my lord, maybe, my lord, the word
we'll
maybe,
consider it's not mandatory.
maybe can become a
this
sale, my
case.
lord.
Yes.
Sale when, particularly
In
when,
view of the fact that you were present at the time of deposition by the witnesses.
my lord. To that extent, that's why, my lord.
That's why we'll read it as a literal meaning.
My lord, that's why, my lord, two line submission I am making, my
We
lord.
cannot read it
My lord
to
will-
something which is not there.
My lord will kindly perish the record, my lord. In the record, my lord, if there is a signature, my lord, I would say, my lord, simply putting my signature in the record is not compliance of this rules 7 sub rule 12, my lord. There should be a specific statement by the inquiry officer saying that would you like to cross-examine? If that is there, my lord, that is the compliance, my lord. If that is not there, my lord, why, my lord, by following this provision, my lord, ultimately this provision is prescribed for major penalty, my lord, not a minor penalty, my lord. When the punishment is bigger, my lord,
Well,
my
let's
humble submission, my
Let's
lord.
see tomorrow. You improve your case. Bring some, have some research on the law.
Obligation.
All right.
Day after tomorrow, my lord.
Tomorrow.
Day after tomorrow, my lord.
Why?
My lord, I'll get some more time, my lord.
After. Okay. I think we have picked some. How many matters we have picked some? 13. Two or this will be three. Okay.
Obvious, madam.
Heard Mr. El Perme, counsel for the petitioner. And also heard Mr. I read up. Additional senior government. Hearing remains inconclusive. This on 13/06/2024 for further hearing. We'll keep it part her. We'll take it back. You find it on these rules. You take the records back and find out what he has meant.
Yes.
He said there must be some mistake, I mean, some record that there, whether you'd like to cross-examine or not. And you also find out some judgment. Your catena of judgment.